Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. Now I will turn over to introducing our speakers for this afternoon so that we can get ourselves underway. We have the wonderful Judge Victoria Wood and Justice James Lambden. Starting with Judge Lambden, since becoming a full-time neutral with ADR Services, Inc. back in 2013, Justice Lambden has engaged in complex dispute resolution and has served as a mediator, arbitrator, referee, mock arbitrator, and appellate consultant in disputes ranging across the breadth of civil disputes. He brings to his ADR practice nearly 4 decades of experience as a trial lawyer, trial court judge, and associate justice of the California Court of Appeal. During his 14 years as a trial lawyer, he represented clients throughout the state in cases involving construction, commercial contracts, torts, secured transactions, employment, insurance, and real estate. And his clients ranged from, wind farm startups to international corporations such as Merck & Co. And then in his 7 years as a trial judge, including more than 4 years presiding over a Master of Civil Law and Motion calendar, averaging 25 to 30 hearings each day. During that assignment, he also briefed the presiding judge weekly regarding settlement prospects of cases coming up for trial. He's also managed the fast track calendar and successfully settled dozens of cases scheduled for jury trials. And since joining ADR Services, Inc., he regularly serves as a referee, both general and special referee across the breadth of civil disputes, which I can attest to as his case manager. Our other speaker this afternoon is Judge Victoria Wood. Judge Wood established her successful track record of settling highly disputed cases during her time as a judge of the Superior Court of Napa County, where she served her community with dedication for nearly 2 decades. Prior to appointment to the bench in 2013, she gained extensive experience analyzing the law as a respected judicial attorney at both the trial and appellate court levels, which prepared her for her role as a judge. And through her work in judicial settlement conferences as a judge, she discovered her distinct passion and talent for dispute resolution and made the decision to focus her career on alternative dispute resolution. She now serves as an arbitrator, private judge, and discovery referee in addition to mediation, and her decades of experience as a judicial research attorney and judicial officer performing the legal research and writing tentative rulings, orders, and opinions for civil law and motion, probate, and appellate matters make her highly qualified and effective in especially this referee role and an excellent resource for our presentation today. So thank you both very much for joining us. And without any further ado, I will pull our slides up and turn it over to you, Judge Wood, to get us started.
Okay, thank you so much for the kind introduction. Appreciate it. Thank you to everyone for being here today. I've been really excited to do this presentation with Justice Lambden because he has so much experience in this area that we all can learn from, including myself, who's kind of a new kid on the block here, so to speak. The way we're going to do it is I'm going to kind of walk us through the basics, and then Justice Lambden is going to be able to chime in with various anecdotes and talk about more of the nuances from his many years of experience serving as a referee. We do have a lot to get through today, so we've broken it down into a few parts to make it a little easier to digest. Part 1, talking about what are referees, how they're appointed. Part 2, when, why, and how to use a referee. And Part 3, we'll go through some little practice tidbits, resources, and forms. So we will get started on Part 1, talking about what are referees and how they're appointed. We don't wear the black and white striped shirt, but I liked the picture anyway. Thank you, Katie. So if you want to go ahead and move to the next slide, Katie. The next slide is going to break down basically how how to think of references. The authority comes from the Code of Civil Procedure, basically from Section 638 and Section 639. And probably the cleanest way to think about it is that you're going to have general references and you're going to have special references. And the general reference can only be done under Section 638, subsection A. And basically that allows a referee to hear any issues, even the whole case. And the referee's decision becomes the decision of the court without any further action by a judge. Special references, on the other hand, they happen either under subsection B of 638 or under 639. And under those, the judge is directing a referee to decide a particular fact or handle certain issues. But whatever determination the referee makes is not an appealable court decision in and of itself. It requires some other action by a judge to either adopt the referee's recommendation or base the judge's decision on some finding. So that's the most basic breakdown, but I think people do still get really confused about the interplay between the two statutes. And so I want to go through that a little more. Katie, if you want to change the slides.
Judge Wood, let me just add one comment. Can you go back to the original slide? Yeah, I'd like to focus on the first bullet point there and make sure that you note that it says to determine any or all. Really highlight any. I think people get it wrong when they believe that the 638A means the whole case goes off to the referee. In point of fact, it's probably most useful when the judge sends one issue or two issues out. Because what I'm going to be doing in my comments is to stress that there's a lot of flexibility available here. People tend to think 638A is general. It goes to a referee and the judge is out of it. As Judge Wood commented, that's not true in the first instance, but it also oversteps exactly how far it goes. And that's true of 639 too. There can be partial references, and that makes it more useful. And the only other comment I want to make is that I'm only quiet because I have decades of working off the back of good research attorneys, and Judge Wood has done most of the work in preparing this presentation, and I want to thank her for that.
Well, thank you. And please don't be quiet. We want to hear from you at any point. So, okay. So just a little more to try to explain the differences between 638, 639. If it's a general reference under 638A, then yeah, the referee is really acting more like a judge in the sense that the decision that's made will be the decision of the court, and will be appealable. You're not going to have a right to jury. The referee will lose jurisdiction once the statement of decision is filed and it becomes appealable. And then under 639, as we mentioned, it tends to be used more for advisory recommendations that the court can either adopt or not. But really under either one, there's really a pretty broad scope of what can happen, right? Justice Lambden, I think that's kind of what you were getting at. There's a lot of flexibility with whether it's general or special reference, and we can go more into that in a little bit.
Yeah, that really was my point, is that we get in the mindset of thinking that all cases are trials, and in point of fact, they're not. It's been true throughout my entire career that something like 97 or 98% of cases are resolved before trial. So in other MCLEs that I've conducted, I've urged people to think of the litigation process more like an expedition than an arrival at the trial. There are various forks in the road that can be taken advantage of to resolve the case in advance. We're going to be giving you some examples of flexible ways to use the reference process with both code sections, 638 and 639, um, to provide tools that will allow you to be flexible in managing the litigation to a successful resolution before trial. And like I said, we'll be giving you several examples of how you can use the referees to narrow the issues in a case. I give you one example right off the bat from my own experience, focusing on that one word that I emphasized in 638 of any issue. And the example would be a closely held corporation with two successful business people who've decided they're going to go their own way and there's going to be a buyout. So there's really only one issue here. They don't want to work together anymore. There's no fight over the corporation other than what's it worth. So sending it to a referee for a 1 day trial of the issue with evidence from accountants and various experts to simply decide, here's the number, that's what it's worth. That results in, in the case that I had most recently, in an immediate mediation and resolution. Maybe they argued a little bit about the number, but they now had a number. The same thing would happen if it were taken back to court. There really wouldn't be much else for the court to decide. So you can use the agreement process of 638 to set up something like that. In other examples we're going to give on 639, you can also manage the litigation, particularly the discovery, in a way that'll allow you to resolve the case much more easily and earlier. So,
Yeah.
yeah, I'm just saying, make sure that we understand that this is really flexible and you can do a lot of things. Anything you can agree on, you can pretty much do.
Yeah. Similarly, but sort of the other side of the coin would be if there's maybe one underlying issue that you need a determination on before you can really even go to mediation to work through all the other issues. That would be an example of a good way to use a referee, get a binding decision on that issue, which then sort of opens up the rest of the case. I have something like that going on, and the issue is standing, and that is a perfect opportunity to use it.
And I would emphasize too that if you're worried about giving up the right to a trial and a jury on a particular issue, you still have the right to appeal that decision if you use 638. And in both of these sections, the court does supervise. So if you were only having one issue decided and then there were other issues, the court would still be involved. And also under 639, if there's a disagreement, you get a second bite at the apple to object to the judge about the referee's decision.
That's true. One thing I want to add before we move on from this slide is that if you're going to use 638, the parties have to have agreed to use a referee. So if somebody is not agreeing, then the only way for it to happen would be for the court to order it over their objection under section 639. So another way to think about the differences there. Katie, you want to? Yeah. All right. So to recap a little, 638A, you're going to have general reference, and the referee's order is directly appealable. A special referee report under 638B or 639 is not directly appealable. The court is going to consider those findings and decide whether to accept or reject them. But of note, those recommendations are entitled to great weight. The trial court needs to give them great weight. Anything you wanted to add on that one, Justice Lambden?
Just to emphasize that particularly under 639, the referee is working for the court. So rather than the parties. So when I'm working as a referee, I'm very cognizant of the fact that I'm trying to assist the court and trying to keep the court well informed and trying to act kind of as a surrogate for the court, so that basically so that the court can do business. When I mentioned the 98% settlement rate, if it went to maybe 3% less, the court system would be overwhelmed. I mean, we really need resolutions, and referees provide a really excellent addition to the tools that the court has to resolve cases. So the independence is there, but at the same time, I'm always speaking to the court to make sure that the judge involved knows what's going on and is satisfied that it's helpful.
Yeah, that's a really good point. Thank you. Okay, so then just to re-emphasize here, a big difference between 638 and 639 is that 638 can only be done by agreement of the parties, but one little nuance to that is that the agreement can come during the case or it can be done pre-litigation through a contract. And I haven't seen this either when I was on the bench or now, but it feels like it could be a really useful tool, and certainly the legislature contemplated it for a reason. Have you seen much of this where the parties decide ahead of time that they want something resolved by a referee?
I've heard of it, but I haven't had one come that way. But I would remark historically, since I'm sort of the institutional memory here, that much of this process has been in the last 20 years or so informed by the practice in arbitration. Because in arbitration, under the rules of most of the providers and even under most of the contract provisions, do provide for really broad authority, similar to what we're going to be discussing with reference to a discovery referee, in a way that allows people to appreciate how flexible it is. For example, in an arbitration, I usually tell people that yes, the default is the CCP, but we don't have to do it that way. If you have a discovery dispute, you call me up and we'll set a call and we'll talk about it. If you can't work it out, then we'll have a motion. You're not stuck with the lockstep of the deadlines in the CCP, which, if they're strictly observed in a big case, can really slow things down. And that's really the whole point of having a referee. It's an off-ramp to approach the problem differently and more flexibly, in a way that the court really can't do because of court calendars and the inertia of really the amount of work that the court has to do. So
And that's
yeah,
why people would opt for arbitration as well. But the big difference here would be that you'd retain the right to
yeah,
appeal.
yeah. And I see the legislature going in that direction because there's been a recognition, all the way back since the 1980s, that more flexible approaches by agreement of the parties, and that's the whole reason that we have such powerful arbitration laws, is that it's basically understood that the parties can agree to pretty much anything they want, and that works in the reference situation too. If the parties sit down and decide that just one particular issue is going to be decided under 638, or that the whole thing would be better off going to a specialized hearing, they can agree under 638. And then under 639, if the court is confronted with the kind of case that's just a monster, or the kind of case that'll be more easily resolved with the help of somebody doing hands-on management, that can be done. And that, in a certain sense, is reflective of arbitration, because that's really what happens in arbitration as well.
Yeah. Yeah, that's what I was going to add at the end of this slide here, talking about under 639, when the court is going to decide to send something to reference, either by a party's motion or its own motion. It basically boils down to the court deciding that it's necessary to do so, which is a big gray area. And
I can give you a good example, though, that we're going to be talking about in a later slide. And that is the sprawling case. It's the case that has 24 defendants, 2 or 3 corporations, maybe an insurer or two, maybe an appraiser, maybe a couple of law firms who've been involved in in this big case for a long time. So you can end up with a case that's really so large that it's unmanageable um, for the court in any practical sense. And we'll talk about that in a minute in terms of examples of how that can help. But you can think about it both as an attorney litigator and as a judge. What do you do with a case that's got 24 defendants, some of whom are tiny and some of whom are international corporations? You're going to have somebody manage that, and that's where a reference is really useful.
Yeah, absolutely. Another place I've seen it is where you have a pro per involved. And I've got one of these going where, the pro per has sort of just enough knowledge to be dangerous, as they say, and making a case that shouldn't be quite so complicated into way more complicated than it should be. And I know in that situation, I suspect that is the second a judge sees a motion under 639, they're going to be real happy to say, yes, send it, send it along. And I'm dealing with that now, and it is challenging, but also it's so much easier for me to manage those challenges when I'm dealing with just a couple of discovery matters, not 30 cases on the docket. So it makes a lot of sense in a lot of different areas. Okay. So there's also differences between section 638 and 639 with regard to the appointment procedures. 638, basically, it allows the parties to kind of get it all figured out ahead of time. I mean, they're agreeing to the reference, and they can agree to who they're going to appoint. They can take care of getting the referee to consent, sign the order, and then package it all up and send it to the judge. Generally, the judge is going to probably get on board with that without too much problems there. 639 can get complicated because there you have one person objecting overall to the reference, but they then also probably, if they're going to have a reference, they want to be able to weigh in on who the referee is going to be. And so there's procedures for all of that that are laid out in section 640. But it can get fairly complicated, and frankly, I see it done wrong all the time. I know you do too, but you have a suggestion on how to a solution for all this complicatedness, right?
I have a couple of comments. One is that historically judges were reluctant to appoint 639 referees because it was regarded as an added expense. The courts are here to provide this service. Therefore, why should we send it outside the court system? But back when I was law in motion, it was those were the days when I think San Francisco had something like 8 discovery commissioners who just heard nothing but discovery motions, which was a tremendous drain on the resources of the court. And over time, the judges have begun to appreciate, particularly in the past few years, I was about to say post-COVID, but it was before that. They've begun to appreciate that not only is it not necessarily more expensive to have a referee, it probably is going to, in the long run, save money. And also the lawyers have begun to appreciate the fact that if they have to wait 3 months to get a motion date, and they have an opponent who is perhaps being deliberately dilatory, the appointment of a referee can be a way around that. So frequently now we're seeing attorneys apply to the court for appointment of a referee, even over the objection of the opposition. And sometimes they use the same system that 638 would apply, and actually do a selection process and propose to the judge that somebody be appointed as referee. So there's a trend in this direction for particularly 639 references to occur because they are so useful to the court and useful to the parties. as people become more acquainted with the process, we're likely to see it happen more often. But they're not fully acquainted yet, and I agree with Judge Wood that most of the orders that I have gotten appointing me as a referee have been clumsy, and the judges also get it wrong. The judicial council form is a little bit confusing, so sometimes you get both boxes checked, appointed for all purposes, and then it also says appointed just to do depositions. So you might have to inquire exactly what the court meant, which is a good place for me to mention that something I'm going to mention later is that the referee can always ask the court for instructions. And I found that to be a very useful thing to do, again, as part of the idea that the referee is working for the court, and the court needs to be informed and confident that the work is being well done. So frequent communications with the court are a good idea.
Yeah.
But
I- yeah.
and at the outset of the appointment, I think we're going to be suggesting that if you're going to use ADR services, we have a full set of forms and can help put the order together, which is very helpful because it can be confusing if you've never done it. Yeah, go ahead,
Yeah,
Nikki.
and I've seen our staff, going back to council to try to clean things up. And frankly, I think they'd be much happier if you just come to them at the outset, even if you're not positive who you're using, but just to ask them to kind of walk you through the process and making sure you're doing it in the simplest and most efficient way. I think they're happy to help with that.
I should mention too that I was flattered one time when a judge who I did not know, and I won't mention the county, appointed me as a referee by sending the order to my home address. I don't even know if he knew I worked for ADR services. So somehow he heard about me and he tried to appoint me without even going through the process, which is fine. I was happy for the work. So.
Yeah, yeah. Well, I know I did it wrong when I was on the bench at least a couple times, so it's confusing. So don't hesitate to reach out at any time. Okay, so I think we've explained enough about the differences between 638 and 639. So for the rest of the discussion today, we're going to focus on the appointment of discovery referees under Section 639, largely because this is probably an area where you see it most often, but also I think that it's going to give us an opportunity to kind of talk about all what Justice Lambden mentioned about the flexibility in different ways you can use it, even if it's done under this involuntary 639 paradigm. All right, I think this is you. You're going to take this slide, Justice Lambden.
Mostly on this one, I just point out that if you look at Rule 3.922, it allows the referee to do a great many things without the initial approval of the court. In other words, you don't have to ask the court if you can do these things. But it does impinge on some aspects of the reference in terms of what you should do as opposed to what you can do. Rule 3922 pretty much allows you to do anything in terms of setting up the hearings, having routine conferences, issuing subpoenas, taking evidence, ruling on objections. All those things that are listed here in these bullets can be done without the prior approval of the court. However, I always will report to the court what's being done, even if an order is not required. And it'd be a good place for me to mention that at least I do a couple of different kinds of reports to the court. I will do a memorandum to the court, which is basically a take your temperature kind of thing. And it has an introductory paragraph that says no order is going to be required here, but here's what I've done. Here's the schedule of what we're going to be doing in the future. Basically just a report to the court of what's being done. Occasionally, it might have a paragraph at the end asking for instructions with either a proposed order or not, but a suggestion that the court can respond. There are other instances, however, that you have to be aware of, and the two on the right side here point that out. There can't be any contempt proceedings. So if you're going to try to enforce a subpoena on a contempt basis, you're going to have to refer that to the court, and you can't order a sealing of records. But those are pretty minor exceptions to the broad power of the referee to actually run the reference. However, you do need to report, the referee does need to report to the court any recommendations that require an order, and also report the expenses that have been incurred and get those approved. So the second type of report that goes in is a report and recommendations with proposed order. And I'll talk about that a little bit more as we go along here. But as to the daily reference work, the referee can do pretty much anything. So if I get the order of reference, I can immediately set the first Discovery Management Conference, DMC, and at that conference, lay out the ground rules for how we're going to proceed with the assistance of the parties, and it's usually a discussion. Which would include what is the order of the discovery we're going to do, what problems are going to be presented in terms of what types of discovery are going to be done, what basically needs to be done to get this case moving. One thing that is quite often very useful in a bigger case is to schedule a regular, like every month, discovery conference with everybody ordered to report, with everybody understanding what the issues are going to be at the next conference, so that they can turn in their homework on the discovery that's been done, have a further discussion, and get some assistance from the referee, which might include setting motions, might include a lot of different things with reference to what's necessary to get the discovery done. But 3922 is the most useful rule that the referee has in this case, and it really is what makes it work, because you don't have to contact the court every time you want to have a hearing.
Yeah. Just so everyone knows, Katie has attached that rule of court 3.922 in the reference materials at the end, so that will be convenient for you. And so you would do an order, a memorandum to the court for everything, because there's certain cases where, if I'm trying to kind of keep costs down for the parties, where I haven't done a memo to the court, but I've certainly done written memorialization of what occurred in a discovery management conference. Would your advice be to always file it with the court?
Yeah, that's why I have two different, because I might have a regular routine discovery management conference once a month in a big case. But at each one of those, not everything, maybe nothing happened. Maybe it was just to take your temperature. But if a court order is going to be required, then I would include recommendations. Here's what I suggest we do with reference to the case. And here's a proposed order that says the parties are directed to comply with those recommendations. And that in one case might be that I'm recommending that we complete all discovery of documents first on a schedule that I would specify, and that then we would discuss interrogatories or written discovery according to a schedule. And I would have the court approve all of that. And partly it's necessary to have a periodic order in any event, because you want to have the payment of the expenses checked and also approved by the court. So the typical full report would be, here's what we did, here's the parties that appeared, here is what they reported. Plaintiffs said they were having trouble getting X, Y, and Z. Defense responded that they needed more time. A discussion of exactly what happened, followed by a list of recommendations. I recommend that we continue to have regular hearings, that production of documents be done by this date, that any privilege log would be prepared necessary for the referee to rule on any privilege issues, that sort of stuff, a list of recommendations, and then a proposed order. The proposed order then at the back end of this report might have a blank in it. It might say that I'm asking the court to specify how many hours would be allowed for a deposition, for example, if there's a dispute among the parties, or whether an additional deposition can be allowed. So the court then will get the full report. They'll see what the recommendations are, and then they will approve what is done. And that's what takes it away from being advisory, is the approval of the court. So you want to have that done. And we'll be talking in a minute about the potential objections to the report as well.
Yeah, you were talking, I just pulled up the Q&A, and there are three kind of related questions about the reports and the communications with the court. And they're asking, are there ex parte communications between the referee and the court? Answer is no. And are the reports also sent to counsel? And I think that that ADR services certainly sends our reports to counsel, and then they get filed with the court. So I guess some of the attorneys are not seeing these reports that go to the court.
That shouldn't happen. Those should be served on everybody, particularly because they have a right to object. And so generally speaking, anything that I do as a referee that is directed to the court is going to be served on everybody. And it is flatly unethical for the referee to have ex parte communications with the court. So over a period of years, I've developed more of a habit than most referees of asking the court for instructions, which is kind of what I do with reference to the memorandum reports. In that context, you can sort of imply or directly ask for the court's suggestion on what you should do. So everything should go to the court from the referee. I would mention, however, that doesn't seem to be exactly the same practice in federal court. Some of the federal judges have been a little bit more inclined to communicate with me as a referee, which I find discomforting, and I make sure that everything gets reported to the parties.
And the follow-up question that came in is, are the referees allowed to have ex parte communications with counsel in the way mediators do? And again, the answer is no.
Yeah, resounding no. That'll get you bounced pretty quick.
Yeah, and we always, you and I try to make that clear from the outset with everyone. This next slide has to do with the report of the final issue, which you kind of already touched on. Anything you wanted to add here?
On this slide?
Yeah, and there are certain things that are required that the referee has to report on, hours spent and how the division of fees, but I think you kind of already touched on all that.
Yeah, I would kind of wrap that up by saying you want to make sure that the court knows how much is being charged, and technically you're not allowed to keep the money until the court approves it. So you do need to get approval of the payment of fees, and that's another thing that gets reported because it describes how much time has been spent. And it's useful for the court to know that, both in terms of the usefulness of it and also in terms of whether the court is getting the benefit of the charges. So that's one reason that you really want to do the report.
Yeah, you can go ahead and go, Katie. This slide is just a little more information on the referee's report. Once that is filed, there's no requirement for the judge to have a hearing. Certainly the judge could decide to do so, could have maybe argument, could actually take additional evidence. It's really up to the judge. But what often happens is the court will simply adopt the recommendation. Of course, that's supposed to be independently considered by the judge, even though they're giving great weight to the recommendation. And the judge has to wait for the objection period to pass. So it's 10 days for objections and then 10 days thereafter for any responses. And this can kind of eat up a lot of time. I know you and I were talking about this, Justice Lambden. It can eat up a lot of time. And so you have a way to sort of short circuit that a little bit.
I try to anticipate problems because in some cases you can be certain that one of the parties is going to object to what the referee recommends. So I've had a hearing on the merits of a motion to compel, for example, and the other side isn't happy. They're going to object. I try to anticipate that and make it easier for the court. I give you an example. A non-party law firm is involved in the sense that they want a subpoena issued to get records from a prior attorney for one of the parties. So you know that there's going to be an objection to that, and you know that ultimately the court's going to end up deciding that. There are some issues such as that one. The referee does have the ability to issue subpoenas, but on the other hand, a party could object that that is beyond the pale with reference to a particular issue, like a law firm under these circumstances. So if you know it's going to be objected to, I try to forewarn the court and go ahead and frame the recommendation in a way that the court can go ahead and deal with it. And in fact, in one of my memoranda reports, or even a regular report, I might suggest that the court just go ahead and hear this, rather than have the two-step of me making the decision and having the final decision made by the court. Don't do that very often because that undermines the whole purpose of the reference. So a thorough report that allows the judge to be confident that the decision has been made and that the recommendation is appropriate short circuits a lot of this. But if you know that they're going to object, you also may be able to structure the order in a way, or the recommendation and the proposed order in a way that will lend even greater weight to the referee's suggestions.
There was a question about tentative rulings, and I know I issue a tentative ruling before hearing a discovery motion, for example, but I haven't done a tentative recommendation before sending the recommendation to the court. If I'm understanding the question correctly, is that how you?
I'd give you a different example, one that we're going to talk about later, maybe in a situation where the referee is observing the deposition of a non-party witness, and the CCP limitation of 7 hours on a non-party witness is invoked. And the party simply gets up and says, well, time's up, we're leaving. The referee, in that case, me, says, well, I don't think we're done. I don't think that's appropriate. The code section allows there to be a longer deposition here. I believe that if we did another 4 hours, we'd be done. So my recommendation to the court was exactly that. Here's what happened. We did 3 days of depositions and we're only able to get so far. My recommendation is that we allow another 3 hours. And then in the proposed order, I put, having reviewed the recommendation of the referee, the court orders that blank hours can be used to conclude the deposition, allowing the judge to fill in the blank based on what I had described in my recommendation, and let the judge decide how many hours you were going to add to the deposition. So again, the idea is that the referee's working for the court, so want to make it as easy for the court as possible. I'd be honest when I say that frequently the proposed orders, I never see them again. I assume they get signed and filed, but they don't necessarily in the bureaucracy of the court make it back to you in a timely fashion. Um, so I just have to kind of hold my breath and hope that they agreed to the order. You can ask the parties, they get a copy, but for some reason, sometimes the courts are very slow in responding. You will hear if there are objections, obviously, but that's up to the court. The court will tell me what to do after the objections are heard.
Okay. All right. I'm getting a time prompt. We're moving on to part 2 after 45 minutes. So,
We better go.
yeah, when, why, how to use a referee. And you kind of touched on this a minute ago. It all really boils down to efficiency. You can use it when there's multiple issues or motions, when those motions are likely to, stall out the case, lessen the delays. I know a lot of courts are feeling big pressure from backlog. Just heard the PJ from San Francisco County talking about the backlog of criminal trials really preventing the civil trials from getting out. She's pushing for the use of expedited jury trials. So anything I think that we have the tools to help the courts with their limited resources, we want to try to take advantage of those for the right case. And that's exactly what this tool is here to do. I think it's kind of a gift and an underutilized gift. But of course, there are issues. I think you've mentioned people sometimes want the process to go slow in certain cases, right?
Well, that's traditionally the problem, which is why discovery is such a pain in the rear end a lot of times. One side wants it to be as slow as possible. Why don't you hit the next slide? This is the sprawling case that I described, where you've got 18 defendants, you've got corporations, you've got truck drivers, you've got attorneys, you've got all sorts of people that have been named, and some of them haven't appeared. There are demurs still going on. All those things are happening in a way that makes it really impossible for the court to deal with that sort of a situation without the assistance of a referee, since we all know that there's going to have to be discovery. So this suggests an order that we used in a case that divided up the expenses to kind of make it fair, so that the plaintiff was paying 20%, that everybody else was paying jointly a portion, because there were a lot of parties who really might not even have answered yet, and are technically not even required to pay. So you're going to have to sort out some method by which the payments are going to be made in a fair way amongst a bunch of parties. And then following that, you're going to have to figure out exactly how quickly to do things in a way that would allow for mediation of some of the parties to get out, for the documents to be prepared in a way so that you can look forward to actually being able to get ready for trial and settle as you go along with different parties. So go ahead.
Well, I was going to jump in on this slide because it kind of talks about using the discovery to prepare not so much for trial, but for an effective mediation, which can be resolving specific issues, or it can be just managing the discovery in a way that gets you to sort of that sweet spot for mediation. Because if you don't have enough discovery completed, you may not be ready to mediate, having an informed decision. But if you get too far along, then you've got the inertia dragging you toward trial and you're less likely to settle. So we all want to get to that sweet spot for a successful mediation. And I actually have this going on in a family law case that it's not under the Code of Civil Procedure. I'm not even technically a referee, but that is essentially what I'm doing, where, the attorneys and the parties are amicable enough to agree to have me help them get through the discovery process and maintain peace to get everything exchanged and deal with the forensics and get us to a point. The goal is to get to mediation and be able to have a successful, effective mediation. And so that is a perfect example of how a discovery referee can be used to sort of guide things to where they need to get for mediation, not let it get blown up prior to that. And there's lots of areas where you can do that, right, Justice Lambden?
Yeah, I certainly agree with that, because in my mediation, sometimes we'll get to noon and I'll say, we're going to stop for the day and I'm going to assign homework. If you would just depose Mr. So-and-so and get some answers, we could come back and probably have a more fruitful mediation. I've also got a pending probate case, which is a good example. Families up in arms, all the siblings after each other, all surrounding, what accounting was done by a particular sibling who was running the decedent's affairs. So starting off, I was going to suggest that we have a discovery referee to deal with the issue of discovering what records there were. But then that morphed into a reference to a special master, which is really just a referee, to do an accounting, or to actually prepare or supervise the preparation of the accounting for the estate, which is really going to be the whole issue. It's interesting that mom always liked you best and you're mad at your brother, but really it's going to boil down to the numbers. So a referee is perfect for that.
Yeah, that's great. Okay, and then of course a big one where referees can be beneficial is when you're dealing with huge volumes of electronic discovery. You had some things to say about that, I think.
Well, frequently, I'll give a couple of examples. I've had a healthcare case where there were literally something like 4.5 million records to be reviewed with reference to charges of particular. I think there were lab results, the charges on that. And clearly that's a number you can't deal with. It's just too huge. So you end up having to do some sort of a search to narrow it down. So in that monster 4 million document case, we had a monthly conference where the parties went off to their vendors to search the records using different terms that they agreed upon with the assistance of the referee, so that they could narrow it down. So month 1, we had 4 million. Month 2, we had 3.5. Month, the next month, then we were down to 2 million. Then we got under 2 million. We finally ended up down to 750,000, which, believe it or not, was something that could be useful, and the case ultimately settled. And it's not at all infrequent now that you'll have cases, even in employment cases, that have these long email chains with all sorts of documents attached. Somebody needs to supervise that. And I'll mention Boolean searches just because I love the name Boolean. I think he was a mathematician, but in any event, it's figuring out how to use search terms to conduct basically AI searches. And you don't need to know how to do it. You just need to supervise it, because the parties are going to get vendors to do that.
Yeah.
But that's something that is very much growing now, because we have so much reliance on electronic storage.
Yeah, I wanted to chime in there because there was actually a question about AI in connection with the electronic searches, and I think now it's the question is maybe less about the actual Boolean search terms, because the AI interface is so clean and more natural language, but you're still going to have conflict about the parameters of the search, and it will likely be staggered where, you do that initial search, you minimize what you come up with, and then you're going to need to come back to the table to say, where do we go from here? And referees can be really helpful for that. I did want to mention, just because I did an AI presentation recently on our MCLE day, a couple of AI programs that are really supposed to be really great. I haven't used them, but especially great for electronic discovery are Everlaw, Relativity, and Disco. Those are the three I'm hearing are working well, and people are using them a lot. Yep, it's in the chat. Thank you, Katie. Of course, we often can be using our services with these antagonistic depositions, and that can have. I thought I was going to have to fly to Oklahoma a couple weeks ago to deal with one. Thankfully, I didn't have to go to Oklahoma in the middle of winter. But obviously we can be contacted by phone, by Zoom. We have a lot of flexibility to participate in these depositions that just cannot seem to make it through without the help of a referee. But you've seen some problems with those as well, right?
Well, this is the example most people think of, is that the attorneys they keep coming across the table at each other and leaving the room and throwing files around, and so a referee gets appointed. The referee attends the deposition and everybody behaves like they're in church. Nobody acts up. But a bigger problem recently has been the migration of depositions to remote access. Because there's a lot of ability for mischief if all the people aren't in the same room in terms of exchanging notes or signals. I mean, I've done some work. Clearly, the witness is looking at somebody over there, and I have to say, who are you looking at, and what are they saying to you? So in the materials, you'll see something that I put together as a protocols for a hybrid deposition, which makes sure that everybody who's in the room with the witness is identified. It gives the court reporters who may be checking in from Florida or Texas the framework for making sure that the record is clear and that nobody is signaling or passing notes or interrupting the deposition. And that's very useful because I think, I'm not sure if it's a majority, but a lot of depositions are being done in a hybrid Zoom session now. And the referee can be very helpful for that.
That order is really helpful. Thank you. I've used it. So yeah, that's going to be in the materials as well. We're getting short on time. There, just a little recap on some of more of the benefits with flexibility and scheduling. I think you were going to touch on a couple of these. Or they're pretty self-explanatory.
Yeah, I think they're pretty self-explanatory. The main thing, again, is that I would stress that you should take advantage of the idea that the referee can be readily available on short notice. I had a call this morning saying, can I be available next week for a rapid hearing? And yes, that allows things to go very quickly. The briefing schedules can be shortened, they can be lengthened, they can, whatever is necessary can be done. So focus on the flexibility and the fact that the hearings can be set at better times and that you can do things remotely and that you can, as it says here, use private facilities. I mean, you can do almost anything. I had a deposition of a guy who was sitting in the front seat of his car and it worked fine. And if you think about how much time and gasoline we saved, it makes a lot of sense.
All right, we just have a minute, so we'll flip through this real quickly. Katie, we've got this is just a list of the materials that Katie has attached, and you definitely take a look at those. They're really helpful. We've also re-emphasized here, feel free to contact ADR Services. They're experts at this. They're happy to help out. In the earlier on in the process, the better, because then everything's going to go more smoothly throughout. And then these are all the authorities that have been relied on in creating the PowerPoint. And this would be nice to keep on hand if you ever run into any issues, any conflict about getting a referee appointed and the scope of the reference. You can refer back to this in your brief if it's helpful. And I think that is it. The last slide, we have our email addresses, which we are both happy to have you email either one of us with any questions you may have that we weren't able to get to today. It's 1:00, but any last thoughts from the sage Justice Lambden here?
Just this is the wave of the future, and you can use this, and do rely on us. The orders are confusing, so if you check in with us, we've done the work to put some information together that should be helpful. And as Judge Wood said, if you have any questions, you can contact us directly as well. But this is going to be something that everybody's going to be using more, and I'm seeing a steady increase in it.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.